some feedback on it. I too, like the Minister, I'm a social worker by background, both Ireland and England. And I also know many friends because domestic violence is something that cuts across class, it cuts across region, and it cuts across age. And I suppose one of the statistics that stood out to me when I was the very useful briefing that Safe Ireland and other civil society organisations gave us to help us get this legislation to be as good as it possibly can be was that 31% of women have experienced psychological violence by a partner, current or ex. That's a third of women. That's a huge number of people affected by something that they shouldn't have to live with or put up with. And the fact that this bill, as well as the physical violence that we all know and don't tolerate, the psychological violence being taken seriously and taken into consideration in the legislation is really, really welcome. And also the impact of abuse on children. And Senator, I think Norris said, trauma not transformed is often trauma transferred. And very often children either become victims themselves of domestic violence or sometimes really tragically become perpetrators. So again, this bill taking into consideration the children's view and the children's impact of domestic violence is very, very welcome. And I think that alongside better law, having better law and an awareness campaign to accompany this, to shift behaviours and attitudes so that we just don't tolerate this kind of thing in this country is very, very welcome. Other aspects are for the court to be held in camera, which is very, very welcome. The provisions for evidence from children to be given by video link, which could be extended to all ages, and the right for people to have support and accompaniment. I also welcome the new provisions on forced marriages, also the emergency barring orders offering protections from adult perpetrators, which are sometimes sons and daughters of older people, but experiencing domestic violence. In the digital age, the last piece of particular importance is that much harassment in intimate contexts is now done by electronic means, and that protection against this kind of behaviour is much needed. This could be strengthened to include communications with third parties to catch the awful behaviour popularly known as revenge porn, and I think that being taken and strengthened would be very, very helpful. The definition. The bill should include a clear and comprehensive definition of what constitutes domestic violence. This definition should not only include physical, including sexual, but also psychological and economic abuse, all the more important given the prevalence of psychological abuse as was reported. And also coercive control, which happens to a great number of people, but again, very hard sometimes to get action, and again, organisations at the coalface have found it very difficult to get orders for non-physical forms of violence. So I think that is important. I welcome the fact that that the Minister is going to amend the relevant section with regards to former dating partners and people who aren't cohabiting. The National Women's Council of Ireland recommends developing guidelines in relation to criteria and considerations for granting orders under the legislation, that these should be broadly phrased to take into account of individual and novel circumstances, as there is a concern that without a clear set of criteria, an open list judges will act inconsistently. There also should be mechanisms to restrict the ability of a respondent to delay or interfere with the course of a domestic violence order application. And Senator Batchik and Senator Burke talked about things going on in courts for years and years and years, leaving people in a terrible limbo. I would like to see changes made so that perpetrators are prohibited from directly interrogating their ex-partners during court proceedings. And again, I have a concern of possible unintended consequences on Section 33(3). It is drafted so broadly that it could criminalise any innocent mention of a case, including the accused identity by the complainant to anyone, for example, in an email to a relative or friend in the course of ordinary private correspondence. the wording, so the wording could be tightened up. With regards to barring orders, the phrase putting in fear is open to many interpretations, and I believe it should be clarified that it refers to the fear felt by the applicant and or dependents of any future violence or abuse or threats of same by the respondents. Again, many people have talked about out of hours and the fact that abuse doesn't happen 9 to 5 or Monday to Friday, and of course that in every instance that the impact on children, and at every point of proceedings, that the impact of children is taken on board and into consideration, and that also that there is a presumption of capacity to give instructions and evidence of applicants with any form of learning or intellectual disability. The case of Grace this week is a timely reminder how important that element would be. And finally, fees should be not a barrier to people accessing justice. So I look forward to working with you, Minister, on this. I think it is so encouraging to know that you've taken this so far and that you're using your very senior position to push this through, because it is much needed. Thank you.
Thank you, Senator. Now, is there no more senators offering